Today we have with us Mr. Michael Edwards. Michael Edwards is a chemist by training who, out of ambition, pursued finance, very interested, and went to do an international MBA, again majoring in finance. He is employed or attached to the Intellectual Property Office in the Ministry of Legal Affairs, and he's going to share with us this most important topic where R&D usually leads. We do a lot of papers in R&D, and most of us would like to reach a point where we have a product or a prototype to take it to patent. And so your presentation today is most timely, and he's going to present us a seminar on patent law and procedures for the filing of patent applications. So let's welcome Michael and his group from the Ministry of Legal Affairs.
Thank you. Hi, good afternoon. I'm going to give you a little introduction into the patent system in Trinidad and Tobago. I'm not going to assume that everyone knows what intellectual property is. I'm going to start off and explain what intellectual property is, first of all, and then I'm going to go on and define what a patent is. Now, innovation could come in many forms. So I have up here Kentucky Fried Chicken. We all know about KFC. Now, what is the innovation in KFC? Now, they came up with this recipe of special spices and herbs. And this special recipe is only known by a few men within the company. And that is their innovation. That is their product. Now, they would have gone on and innovated in terms of the cooking process. They would have gone on and come up with machines, etc., to make it easier for them to create this special chicken and fries. And they would have protected that innovation. Now, the actual recipe is not protected by way of a patent. They would have used a trade secret. I'll explain this a little more. Apple created the iPhone. That's another innovation that we all use. So basically, I'm trying to show you examples of innovation where you see that we use innovation in everyday life. So it's important for us. No problem. A simple innovation was the post-it notes. Yeah? It was actually created by two guys. One of them came up with the idea that he was going to create this super adhesive. He didn't quite succeed. In fact, the adhesive that he created was so weak that you could have just pulled it off. But another guy came up with the idea, hey, when I'm reading a book, sometimes I lose the pages. How can I keep these pages? And he came up with the idea of using this adhesive, and post-it notes was born out of that. So you see, innovation can come in maybe the smallest of ideas, the biggest of ideas, the grandest of ideas. But after you innovate and you come up with a product, what happens next? And that's what I'm here to tell you about. So what is intellectual property? Intellectual property is creations of the mind. Anything that you create, that you use your mind to create, is intellectual property. So it's an invention. It's a book that you would have written. It's a song that you would have sung. These are creations of the mind, and these are what we call intellectual property. Now, it's a little different from what we call intellectual property rights. So the intellectual property rights are what are granted by the state, usually for the intellectual property. Yeah? Now, a mere idea cannot be protected via intellectual property rights. We can only protect the tangible form of that idea. So if you write a book, we can protect the book, the story. If you sing a song, we can protect the song. If you have an invention, we can protect the invention. Yeah? So we can't protect mere ideas. So as I mentioned, it has to be in the expressed or manifested form. That is the way we can protect it. It's the object created from the idea or a detailed description of the idea using language and other symbols. And that's what we refer to as intellectual property. And these are the rights that we call intellectual property rights. It's a bundle of rights or entitlements. It entitles the owner to do certain things. It also prevents others from doing certain things. And it's regarded as a negative right. Meaning then that if you're granted intellectual property right, it doesn't necessarily give you permission to market your product or sell your product within Trinidad and Tobago. But what it does, it prevents others from using your idea, from using your product within our market. And of course, it's used as a business tool. Companies use intellectual property rights to create what we call competitive advantage. In other words, they need to tell the consumer that, hey, I have this unique product, and my product is better than any other product out there. And that's why they use intellectual property rights, to kind of fence around their product. So intellectual property rights are something that you own. Yeah? You can sell it, you can license it, you can do anything you can do to normal property with intellectual property rights. And for business, it's an asset. Because businesses will trade intellectual property rights. You'd see it on the news all the time. You'll see like a big company like Microsoft would license software to a smaller company. Yeah? They would buy a smaller company to get access to their patents. They may sue Apple for infringing on their patents, etc. So it's used as a business tool. It's used to negotiate. It's granted by a legal process. Patents especially are granted by a legal process. Now the exception with that is copyright and related rights, which is automatic in Trinidad and Tobago. So I have the different types of intellectual property rights. So you can think of the intellectual property rights as a big tree with two main branches. On one side, we have what we call the copyright and related rights. On the other side, we have industrial property. Now, industrial property is what industry uses to protect their product. So we have trademarks. We all are familiar with trademarks. This would be like the Nike logo, the little swoosh. Yeah? Patents, which is what I'm going to talk to you about. Industrial design. That is really for the design of the product, how it looks, how it feels. So for instance, this pointer that I have here, it has a unique design. It's, and that is what we consider for industrial design, this unique design on the pointer. Geographical indications. Geographical indications are similar to trademarks in nature in that they tell the consumer that this good has a particular quality, but the particular quality is based on where it originates from. So, for example, we have Scotch. Now, Scotch is whiskey created in Scotland. So, Scotch tells the consumer that this whiskey tastes a certain way because it was made in Scotland. Whether that is so or not is disputable, but Trinidadians like to believe that is so because we enjoy Scotch more than any other whiskey. Integrated circuits, it's a form of protection for the layout design of an integrated circuit. Now, the layout designs are important in integrated circuits because they allow the manufacturer to make the circuit smaller and smaller. Yeah? While they may spend years to research and develop it, it's as easy as making a photocopy. So there's a special type of protection for that. And then we have new plant varieties. So new plant varieties are for when you create a new variety in a plant. And we have a special right for that. And I have a list of all the different copyrights and related rights that we have. Now you notice there we have works of mass, and that's actually unique to Trinidad and Tobago. Yeah? So I have some of the legislation governing the different types of intellectual property. Patents. Now I have some examples of some patents here. I have the Segway. I have the BlackBerry. Now actually there's an interesting case with BlackBerry. BlackBerry was sued for patent infringement when they came out with their BlackBerry phone. And they lost the initial case. even though the patent was later invalidated. Yeah? But they lost before the patent was. That qualify for patent. Now, the invention could be a product or it could be a process. So, for instance, if I have a pharmaceutical, I can either patent the actual pharmaceutical or I can patent the process of making pharmaceutical. Yes? Now, in patenting a process, the product would be protected. Unless, of course, the person can find an alternative route of making the product. Yes? So, that is what a patent is about. Now, why would you want to patent something? Anyone? Why do you think you'd want to patent something? You came up with an invention. Why do you think you'd want to patent? What's the need for a patent? Well, the simple reason is, don't rush the answer. The simple reason is, you patent the invention, one, because you want to say that, listen, I own this invention. Two, you actually want to exploit the invention. So you want to make money from it. Most people, they innovate for two reasons. One, they want to make money. Two, they actually have a problem that they're looking to solve. And those are the two main reasons people innovate. And you'll patent because you want to make money off the invention. And the patent system is really a way to promote this inventiveness in society, to promote innovation, to encourage people to innovate and look for solutions to problems. Because I may not be the only one to have this problem. There may be other people out in society facing this problem. For instance, patents are a way for pharmaceutical companies to innovate and come up with drugs that each and every one of us use today. Yeah? So when you get a patent, what rights does the patent owner have? Now, the patent owner has the right to decide who can use his invention and who cannot. So, a lot of people have good intentions. They go into it because they already have a problem and they're looking to solve. And then they think about it and they say, listen, I don't want to really make money off of my invention. I want to give it away free. By having a patent, you can decide who you give it to for free and who has to pay you some royalties for it. Yeah? The owner may give permission to or license to other parties. In other words, you may not be able to exploit the patent or you may not be able to exploit the invention yourself in another jurisdiction. But you can then license it to someone so you can still make money off of it that way. And this other company may be able to exploit it better than you can. The owner may also sell the invention. So as a university, it may not be wise to go out there and actually manufacture the product. But you can take the rights that you have in the patent and you can sell it to a manufacturer who can make it for you on your behalf. Again, what is the purpose of a patent? It is to provide inventors with an economic incentive. There is a great drive in being able to make some sort of financial, economic benefit from an invention, from a solution to a problem. Recognition of your work. As the inventor, you will always be named on the patent document. You will always be named as the inventor of this invention. to encourage innovation and to stimulate development. It is also used as a tool to encourage foreign direct investment. Most countries, when they're trying to encourage foreign direct investment, what they try to do is they try to strengthen their intellectual property rights system to encourage companies from China, the US, etc. to come in, telling them that, hey, we recognize that this is your property, this is your intellect, we will protect it for you. The period of protection of a patent, especially in Trinidad and Tobago, lasts for 20 years. In other jurisdictions, it may not last 20 years. But most of the major jurisdictions, it is for 20 years. So patents are not forever. The idea is that you have a period of time to exploit this. And in fact, this is the basis of generic drugs. So a generic drug is really a drug that has come off patent period. Yeah? So these generic companies, they take advantage of that. They understand that they don't have to recoup no research and development costs. All they need to do is recoup their cost in manufacturing product and selling the product. So they can do it cheaper than the innovator most of the time. So they can compete on price. And that's what they do. After the 20 years, they will reverse engineer it and they will come up with a product. What kind of protection does a patent offer? Now, patents are jurisdictional in nature, meaning that if you get a patent for Trinidad and Tobago, it's only for Trinidad and Tobago. It's for no other country. So, within Trinidad and Tobago, nobody else can make your product, nobody else can sell your product, nobody else can use your product, they cannot import or distribute your product. They can't even stockpile to distribute it. That is illegal. Only the rights holder can do those things. And that's the protection that is offered to you when you get a patent. The trade-off. Now when you get a patent, it's a trade-off you're actually making with the government. Now, what you're doing is you're telling the government, listen, I understand that my invention is important to society as a whole, so I'm going to tell you how to make my invention. And the trade-off is, I want sole and exclusive rights on this invention for 20 years in Trinidad and Tobago. Now, why would the government of Trinidad and Tobago enter into that kind of relationship? The truth of the matter is, they want Trinidad and Tobago as a whole to benefit from any invention, any innovation that takes place. So it's in the government's interest to take this information and get it into the public domain as fast as possible. And so by telling the government how to make this invention, it's easily accessible to researchers. So for instance, universities come to the Intellectual Property Office and they can request information on a granted patent. So they can get that information and they can build on it. So they can innovate further. So it is actually a way for the country to develop. And that's the reasoning behind this. In terms of the actual inventor, it's useful for him to enter into this relationship because he's actually getting a monopoly for a period of time. So he has 20 years to manufacture, create a trademark that he can build upon, get goodwill on, and sell his product. So he has that, what we call first mover advantage, because he'll be the first one in the marketplace. Now, what is the criteria for patent protection? In Trinidad and Tobago, we have three main criteria. The first one is novelty. Now, when we say novelty, we're talking about worldwide novelty. So it has to be new, not just in Trinidad and Tobago, but throughout the world. Yeah? The second criteria is inventive step. Means then that it cannot be something that is fairly obvious to someone working in the field. For example, I make chairs, and we all make chairs, and all chair makers know that when you have 3 feet on a chair, is the most stable configuration. And a 4 foot, doesn't do anything for the chair itself, It's just ready for style. It looks like they have four. So if you even add a fifth one, there's nothing done to the structural integrity of the chair. So that is something fairly obvious if people working in chairs, a chair manufacturer, etc. So that's an example of inventive style. It can be something that is fairly obvious to someone working in the field. Not just anyone, but someone working in that particular area. And the last one is industrial applicability. In other words, it must work. Yeah? Now, how do you go about applying for a patent? Now, in Trinidad and Tobago, the application process is actually quite easy. Getting a drafted specification is usually the challenge for most individuals, because there are very few patent attorneys within Trinidad and Tobago who can actually draft the application for you. But basically, what you're doing is you're trying to convince the examiner, the patent examiner, that listen, this thing is really new, it's really inventive, and it can do. So you're building a story. So you start off with the description of the problem, which is the background. So you'll tell us what the problem is. Then you'll tell us how you overcame this problem. Yeah. Then the last thing is you will tell us is the claims. What exactly you want protected. So if this is your invention, the claims tells us exactly the criteria for your invention, what it is you want protected. And you also include any visual materials that help sell your case. So if you have some drawings to depict the invention, you provide the drawings as well. And once you have the specification made, you submit it to the Intellectual Property Office. So the Intellectual Property Office within Trinidad and Tobago are the ones that grant patent protection within Trinidad and Tobago. No other organization within Trinidad and Tobago can grant those rights. Only the Intellectual Property Office. And what the examiners will do is they will take a look at the application and they will check databases globally to see if it is in fact new, if it is in fact inventive. And they will read through the document to see if it makes technical sense. So examiners are usually proficient in an area. Now, as Dr. Bridgemohan mentioned, I'm a chemist, so chemistry is my area. So I will examine applications that are chemistry based, and I'll be able to tell you, this makes sense, this looks like it will. We don't actually go out there and produce the products. Yeah? We just, based on the write-up, we'll think about it and we'll say, yeah, this can work, this can't work. A question that a lot of people ask is, can I get a worldwide patent? Because many people think about it and they say, a patent in Trinidad and Tobago really doesn't make much sense. Trinidad and Tobago is 1.2 million. It's so small. I would like to get a patent globally. But the truth of the matter is, there's no such thing as a global patent or a worldwide patent. And that's because each country wants to maintain their sovereignty. So, if you want a patent in the United States of America, you have to go to the United States of America and apply. If you want one in Trinidad and Tobago, you have to apply to Trinidad and Tobago. Now, throughout the world, we have regional offices, meaning that some regions, some countries came together and they created a regional office. So you can go by this regional office and get a patent for that region. One such example is the European Patent Office. So there are about 27 countries in Europe that came together and said, listen, we think it's a little more efficient to have one process. So you apply to the EPO, and the EPO will grant for these 27 states. There's another one in the African Regional Intellectual Property Organization. That's another regional office. Now, we also have what is the Patent Cooperation Treaty, PCT for short. Now what it is, it's a system that makes international filing simpler. You file one application with the PCT, and it's like simultaneously filing in 147 different countries. Because there are 147 signatories to the PCT, which is the Patent Cooperation Treaty. So it now makes it easier for you as the patent Well, you're looking to get a patent, you're not actually patent owner. But you're looking to get a patent, and it makes it easier for you now. So you don't have to go and physically drop an application in 147 countries. You file one, and it will be processed, and it will be dropped in these 147 countries for you. Now, the beauty of the PCT is, they will also do a preliminary search for you as well. So they will do a search, and they will bring up all the similar documents, all the similar inventions to yours, and they will provide it to the 147 countries. They will also do an international preliminary report on patentability. So this is a little report that will say, hey, does it meet novelty? It will tell you if it meets the novelty. It will tell you if it meets inventive step, and it will tell you if it meets the industrial applicability. Yeah? Now, if it doesn't meet all three, it doesn't necessarily mean you can't get a patent. What happens in reality is there's some negotiation that takes place. So the examiner may tell you, listen, the way you are wording your claims, etc., is not new, is not invented. You can't get a patent with the way it's worded. But you can narrow down your claims a little more. You can focus it a little more to avoid the existing patents. So patent drafting is actually an art. So you do a search, you find out what is out there, and you're trying to draft your application to kind of weave a little route throughout all the inventions that already existed. Yeah? So the PCT, as I was talking about it, makes it a lot easier. Now, the PCT also extends it at the time a little bit for you. Now, the first criteria that I mentioned is novelty. What happens if you make an application to Trinidad and Tobago, and then you'd like to go and apply afterwards to maybe the US, maybe to Canada? What happens in that case, especially with novelty? Well, remember you're doing a search globally. So if you do it for some time later in Canada, they do a search, they will pick up that Trinidad and Tobago application. And that Trinidad and Tobago application will make your application in Canada no longer unique, no longer new. Because they will see it's existed before. Look, there's a Trinidad and Tobago application. Now, there's an international convention called the Paris Convention. Now, the Paris Convention gives you some time, some rules. So instead of someone having to meet 200 or 140 or even 4 or 5 simultaneous applications, they can make one application and then they have 12 months to make subsequent other applications. Yes? So what it means then is that your novelty is not affected if you make the other applications within 12 months. PCT now extends that time a little further for you. PCT extends that time to 30 months. Yeah? So you now have 30 months to enter into what we call the national phase. So PCT is divided into 2 phases. You have the international phase, and then you have the national phase. Now the international phase is where it's before WIPO. So that's where the search is done and international preliminary report on patentability is done. That's the international phase. The national phase is when you actually reach before the individual countries that you have designated. So you can designate up to 147 countries. And the national phase is when you actually reach before those 147 countries. Now, PCT is not a worldwide patent. So you still have to go before each national office and prosecute. Yeah? And you still have to comply with the legislation of all 147 different countries. Now, extending for 30 months is significant. Because just imagine you're Trinidadian and you want to apply in, let's say, China. One, most of us don't speak Chinese or Mandarin. Two, we have to find a lawyer who speaks sufficient English to understand your invention, to understand what you're saying, to be able to translate from English to Chinese. Yeah? That is going to take some time. So the 30 months is a significant step. So some examples of some biomedical products. I have the Nike prosthetic leg. Yeah. The MRI machine, and a robotic arm that can pick up an egg. Now at the time, that was significant because, well, I don't know how many of you are actually in robotics, but to get that arm to sense the pressure that is put on the egg, to pick up the egg without breakage is actually a significant step. But that was some years ago. So today it mightn't be so significant, but at the time it was significant. Technology licensing. So after you've gotten a patent, what's the next step? Yeah. A patent is no good unless you do something with it. That's the truth of the matter. It's just an expensive piece of paper that you would have had. So after you get a patent, you have to think about marketing your product. Can you make this product on your own? Do you need to enter into an agreement with someone else? Technology licensing allows you to enter into agreements, so whereby you can license your product to someone else for a fee, what we call royalty fees. Now, without intellectual property rights, you wouldn't be able to do that. Yeah, because you wouldn't have anything to leverage, you wouldn't have anything to sell, to negotiate. If you don't have a patent and you release it into the public domain, it is now free for everyone to use. Once it's in the public domain, there's no coming back. Yeah? And the first criteria is novelty. So if you have an invention and you put it out there and it's in the public domain, your novelty is always affected. It means that whatever it is you have will no longer be novel if you do decide to go afterwards and try and apply for a patent. Yeah? So the first things first, if you think you have something that is patentable, do not put it in the public domain. Yeah? You can continue to work on it in the privacy of your lab, develop it further. When you think you have something that's really unique, go ahead and apply for it. Once it's in the public domain, there's no coming back from the public domain. Trinidad and Tobago learned a hard lesson with that in the steel ban. We can no longer protect the steel ban because it's in the public domain. So nobody will come and say, hey, I created the steel ban. Yeah? Now, of course, if you don't have any control over your invention, how can you be able to seek remuneration for it? It's not yours, it's free to everyone to use. Now, I also mentioned the trade-off. That you're trading off with the government, you explain to them how to make this product. Patents are also jurisdictional in nature. So let's say you decide you only patent your invention in Trinidad and Tobago. Because of the trade-off you made, that patent literature is freely available to the public. So I can go to the IPO and I can ask for it. I can take the documentation, see how to make your product, carry it to the States, begin manufacturing because you didn't patent it in the United States of America. What I can do is sell it in Trinidad and Tobago. But you will see the US market is 250 million persons anyway, so I mean, I don't need to really sell it in Trinidad and Tobago. So all of these things you have to think about when you're looking to go after patenting. You also have to think about what markets you want to. Do you go after 147 countries just because you can? Do you have the finances to go after 147 countries? Because it's going to be expensive. You're looking at translation costs, you're looking at lawyers in all 147 jurisdictions. I mean, the costs can be enormous. So you're going to choose the markets that you think your product will do well in. You might choose the US, you might choose Europe, you might choose Trinidad and Tobago just because it's your home market, etc. Patents give you that ability. By getting the patents in these different jurisdictions, you can control how it's sold in these jurisdictions as well. You can license with a patent. That's the beauty of patenting and technology licensing. A lot of inventors, however, go into a technology licensing negotiation believing that they can negotiate for 50% royalties, etc. Now, I will tell you, in practice, it's usually single digits. Yes? It's not 50% as most people seem to think. The reason being, the manufacturers will tell you, we are taking a lot of the risk. You have a product that is unproven. Yes, you have the idea, and yes, you may have a blueprint fit. But can you actually manufacture it in its present form? Do we have to tweak it so that we can now manufacture it? All of these considerations the manufacturer has to think about. So when you're going into negotiations, it's better to go in with a realistic view. Now the Intellectual Property Office. Now I'm from the Intellectual Property Office. What does the Intellectual Property Office do? What is their role in all of this whole patenting system? Now we're the ones, after you apply, we're the ones who actually examine the application. So we look at the application and we'll say, we believe that you have met the 3 criteria under our legislation and you can get a patent. If we don't believe it has been met, we'll deny it. Now, of course, as I mentioned, it's a negotiation process. So you will come back to us and you tell us, listen, I believe I've met, and these are the reasons, and you will even amend your case to narrow your focus a little bit. And it may go back and forth a little while until you have a patent granted. Now, we also collect and make available IP-related information. So, all the patents that have been granted in Trinidad and Tobago, we have a database for that. So you can come to the office and see what has been granted in Trinidad and Tobago. We also have computers and links with databases in the USPTO, the European Patent Office, etc. that you can also see, not just granted patents, but you can see the applications. And you can come down, you can take a look at the application, you can take a look at the applications, and you can see if anything is related to the research you're doing. There's no need to really duplicate the wheel, as we say. So if you have an idea for a research topic, a research project, you can actually come down to the office and say, listen, this thing has been done to that already. There's no need for me to do it. Or you can take what has been done already and you can build on it. We also record IP transactions. So anything that is done on the patent is recorded at the Intellectual Property Office. If it's sold, it's recorded at the Intellectual Property Office. If it's licensed, it's recorded at the Intellectual Property Office. If it's mortgaged, it's recorded at the Intellectual Property Office. We also assist in resolving disputes. At least we try to be the mediators if there's a dispute. I mean, to date, patent disputes hasn't really arisen in Trinidad and Tobago. It's usually on an international stage, and that usually leads to court cases. I mean, there are a lot of court cases going on. Recently, we had Apple suing Nokia for infringement of their patent. They're claiming that their touchscreen technology that they got a patent on, Nokia and all the other phone companies have infringed on their patent. And Nokia, in response, what they did was they sued Apple. And they say, we have a number of patents, and we have licenses with all the other phone companies except for Apple. So therefore, you're the only one that can use this to their compass. And that's what happens in the international arena. We provide IP advice, meaning that you can come and access for advice, not related to an application order, because we can't give that kind of advice for free. If you want to find out if your invention is in fact unique and to get a patent in Trinidad and Tobago, you have to apply, and then we will tell you if that is so. But we can't provide you with advice on the different types of intellectual property rights. We can tell you what a patent is, we can tell you about the patenting process, we can tell you about trademarks, etc. Because most of the time, intellectual property rights don't go singly. You usually use a combination of them. So after you've started manufacturing your product, after you've gotten your patent, you'll be looking to get a trademark because you want to sell it. You're going to create that brand that catches the consumer, that tells the consumer, hey, mine is different. Yeah? Because after that patent period has expired, that is what you're going to be counting on. That brand that consumers recognize. We also participate in the development of international agreements and treaties. I mentioned a few today. The Patent Cooperation Treaty, the Paris Convention, there are a number of international treaties. What we do is we go out there and we negotiate on your behalf. We negotiate treaties that are beneficial for our countrymen. And we provide patent information services, as I mentioned before as well. So we provide information on existing patents, we provide information on foreign applications that are already published, etc. You can get all this information at the Intellectual Property Office. Limitations to IP I know I've made patents sound so glorious, but there are limitations there. One, they expire. Patents do not last forever. They are limited to jurisdictions. You have limited use without permission. So when I say limited use without permission, research is one such use. So you can't do research on an existing patent without needing to get permission from the rights holder. I have other examples of limited use without permission. Copyright, you can copy. If you're a lecturer, you can use quotations from a patent document. You can use quotations. You can use excerpts. You can do testing without permission from the rights holder. And that's the end of my presentation. Any questions? No questions? Yes.
There's no chance you will to reapply. You probably have to do some innovation to that specific pattern and then reapply.
Well, that's the thing. Once the patent expires, it now comes into the public domain. And as I mentioned, once it's in the public domain, there's no coming back. So what you can do is you can innovate and add some new features, etc. to it and bring it back as an application that may be granted or not. Yeah? Now, in the pharmaceutical world, there's a term that we use called it evergreen. The pharmaceutical companies do this. So they try to keep a product, a successful product that they have on patent for a long time. And so they may come back with an isomer of it and say this isomer works better because of X, Y, Z. Sometimes they may get it granted, sometimes they may not.
You mentioned before that the patent is an expensive piece of paper. How expensive exactly is it to apply?
Okay. Now again, applying to Trinidad and Tobago alone doesn't really make much sense, right? Now Trinidad and Tobago fees, I mean, they're quite insignificant. They might be 2,000 to apply before the office. Lawyer fees are significant, however. But the great news is most countries apply the same standard in terms of the specification. So if you get it drafted, say in the US, you can bring that same specification to Trinidad. Similarly, if you get it drafted in Trinidad, you can carry the same specifications in the US. The problem arises, however, when you're looking to translate. So if you go in, say to China, you need to translate it into Mandarin. In Europe as well, they have 3 languages. So in application phase, there's no need to translate. However, if it is granted, and then they need to publish it, they have to publish it in different languages, so you need to translate. So that will also send up your cost. So your cost will depend on how many countries you apply to, etc. Now, there have been some estimates that to apply to the more developed countries, it will probably cost you around $500,000. Yeah?
But the major cost is to keep the patent alive.
Yes.
It's the initial cost, okay, you can afford, but to keep it alive for, say, 20 years or so, and especially in the international arena, and it's enormous. No individual can afford to do it.
Yes.
It has to, your company has to come to your rescue, or your organization, your university, but individually no one can afford to do that. I have 14 or 15 patents to my credit, but I have to transfer that to my company because the cost was coming to something like $20 million a year protecting them. But a company which had the turnover of 15 billion US per year, that company could afford it, not me, a poorly paid engineer in the company. That is enormous.
So he's correct actually in that, especially in Trinidad and Tobago and a lot of countries globally, you have to pay to keep the patent on the books. And we call it annuities. It's due every year. It's due on the anniversary date of when you file the application. Now, if you did it by PCT, it's on the international filing date. If it's local, it's on the local filing date. Yeah? And it's due every year. In Trinidad and Tobago, we start off at 200 TT the first year. And then it rises exponentially to about 30,000 in 20th year. So every year you pay these fees. And you can see, the more countries, the more fees you have to pay, the more you pay. And our fees are in TT dollars. Imagine if you have to pay in US dollars or in euros, etc. It could be an enormous cost. That's what you mentioned.
Yes.
How many patents have your office granted?
I don't know the exact figure, but we have quite a backlog of applications. We grant about 60, 70 a year. We have recently hired more examiners, so we're hoping to speed up the grant process a little more. But we grant about 70 a year. So I don't know what's the total number of granted patents.
So you have a lot outstanding, you said?
Yes. To be honest, all countries have a backlog. It's not unique to Trinidad and Tobago. It's just the way it is with patents. So sometimes you, well, not sometimes, in most cases you wait 2, 3, 4 years down the road before it's granted. Even the United States, which have a lot of examiners, they take about 2, 3 years, and they have a backlog as well. Yeah?
What's the government some of the time they hold a patent for? So it expired.
20 years.
20 years.
20 years in Trinidad and
Everywhere it is.
Tobago.
Almost.
Yeah. Well, the thing about it is, in the TRIPS agreement, now, okay, let me just kind of back. Now, when you sign on to the WTO, which is the World Trade Organization, you automatically sign on to what we call the TRIPS agreement. And the TRIPS agreement is the trade-related intellectual property rights. And what it sets out is the minimum standards for intellectual property rights. And inside the TRIPS agreement, it sets out the minimum amount of time for patents is 20 years. So you will never find anybody who will be below 20 years. And for prudence, most people will not go above 20 years either because there's a way to negotiate as well in trade agreements. They call it going TRIPS plus. So in practice, most countries have 20 years. Any other questions?
Are there alternatives to doing patents considering the disadvantages now?
There is an alternative to doing patent. In fact, the first example I gave you, KFC, when they came up with this recipe, that is an example of the alternative. Now, what they did was they took their recipe, instead of applying for a patent, they kept it a secret, what we call a trade secret. So you have the option in that you can, if you think you can keep this a secret, you can have a trade secret. And trade secrets are protected indefinitely for as long as you can keep it a secret. Yes? Now it works best for recipes. Yes? Because I can give you a recipe, both of us can use that recipe, and mine can taste totally different than yours. However, for a product like a pharmaceutical, which is easily reverse engineered, trying to keep it a trade secret is a very difficult thing. Yeah? So that is what you have to weigh out. Is it a product that you can keep in a trade secret? Can it be easily reverse engineered? So that is the alternative to patent.
So if someone steals a straight recipe and they will get arrested or whatever, then is that a felony, sorry?
In Trinidad and Tobago, under the Unfair Competition Act, it is in fact a criminal offense. Yes? It's also a civil offense in that the rights holders, such as KFC, they can actually sue you if you stole the recipe from them. Yeah? So there's both criminal and civil elements.
Only the franchisees can use.
Yes.
But they are 200 in the agreement.
Michael, what is geographical rights?
Geographical indications, as I mentioned, is where good derives, well, at least that's the assumption that's made, that a good derives its reputation, its quality from where it originates from the geography where it originates from. So I gave the example of Scotch, but there are other examples. We have champagne. We have a lot of examples in spirits. So we have champagne, which is a sparkling white wine made in the Champagne region of France. We have Persian rugs. So only these rugs manufactured in Persia using their particular standards can be called Persian rugs. Now usually what it is a group of them will come together and say, listen, we think our good has a certain quality because we are making it. And they will set up these standards that they will guide all the different manufacturers with. So each manufacturer will now have to meet this standard. Then they will be able to say, listen, this is a Persian rug, this is a champagne, I can stamp champagne on my sparkle white wine.
Just in Persian rum. So you could make a rum in Tobago and call it a Persian rum?
No. It has to be made in Persia. It could only be made in that particular geography. Yeah? So only sparkling white wine made in the Champagne region of France could be called champagne. Anywhere else is just sparkling white wine.
You'll be surprised that in Soviet Union, erstwhile Soviet Union, where at one time I used to go almost every 3 months, course of my business, they were making champagne. They will call it champagne. And recently they will call it champagne in the Russian language. There was no regrets on their part, no nothing, champagne. Japan I found, that was way back in 1986, 87. The company made whiskey and called it scotch. So they immediately came under, dispute, and immediately they had to withdraw and they had to pay £500,000 sterling pound as the inactive firm. They went to WTO and all that. So in Japan they were making scotch, in Soviet Union they were making champagne, and you will be surprised that cognac, again cognac is the place in France.
Yes.
Isn't it?
Yes.
You go to Armenia, again, and they were making cognac left and right and calling it cognac only. But they, later on, they called it Armenian cognac.
Yes.
And this was the most favorite drink of Winston Churchill. So that's why it became very famous, Armenian cognac.
Yeah.
So, but they were calling it cognac. And well, nobody protested. It's a place in France.
Well, actually, that's how you have the Tennessee whiskey coming about as well. They had this whiskey that they thought was similar to Scotch. And, they couldn't use the word Scotch, and so they came up with Tennessee whiskey.
That is bourbon.
Pardon?
That's bourbon.
This is whiskey. It's whiskey.
Tennessee whiskey.
It's whiskey.
Southern whiskey is a bourbon.
Yeah. You have a question?
Yeah, the 60 to 70 that you brand per year, is that from Trinidad and Tobago individuals or is that from outside companies, foreign companies trying to protect their
98% of the applications we get to Trinidad and Tobago from international companies. Yeah. We get maybe 1 or 2 a year from Trinidadians. Yeah. And the fact of the matter is Trinidad and Tobago is a small market. Most of the locals prefer to go to the US market. So sometimes we may get TCT application from a Trinidadian, but they would have applied elsewhere. Yeah. Trinidad is just a small market, and a Trinidad patent is worth more than an international company than it is a local. Especially the oil and gas. We get a lot of applications in the oil and gas industry. And we get from not only BP and BG that operate, but we get from like Statoil, I think, that do not have operations in Trinidad and Tobago. Because at the end of the day, it is in fact a business tool, and they want to ensure that BP and BG still cannot use their technology for free.
But they can still ask for the downstream processes, maybe. Mostly, I think you will be getting only that downstream, not the primary process.
Yes. Growing up, I'm thinking a little more about why we're taking out the Shakonian and we put a pattern that we can't use it in
The Shakonian?
Yeah, the Shakonian flower.
Patents are only for inventions. Now, in Trinidad and Tobago legislation, you cannot patent a plant. Yeah? That's the first thing. Now, We have what we call new plant varieties, which is like breeders' rights. That's a different type of intellectual property right. But that's for a new variety that you would have bred. So in other words, you can't take an existing variety and get any rights for it. So in other words, nowhere in the world they can take an existing variety and try and get any sort of intellectual property right. It must satisfy that new. It must be new. It must be a new variety. So they can take it, they can breed it, and they can create a new variety, and then they can apply for protection plan. Yeah? That criteria of novelty is always worldwide novelty. It's not just international, it was always worldwide novelty. Any other questions?
A lot of agriculture produce, like even the herbs, they have been patented in the US. I don't know how. I mean, say take the example of, have you heard about basmati rice?
Yes, I heard that.
For example, it is a purely Indian produce, and yet the patent has been taken by some of the American. I think one of the American companies, basmati rice, I couldn't believe. Only, the saffron,
yes.
The yellow powder which you put in our vegetables or dal or whatever it is.
I think it was
the
a
patent is with the US, yeah?
I think somebody tried to validate it about that.
Yes. Then the government of India moved and they came into the picture and they served with that it is of
But most of the times, it's surprised the open country might go abroad and they can patent. Like, for instance, we had a patent on the steel patent. It was on Trinidad and Tobago. When the US what he did was he patented the arrangement and notes on the steel patent. But I mean, we know the arrangement and notes. But it wasn't validated. The government of Trinidad and Tobago took it up and invalidated it.
It's just a comment with cost involved. It's a major deterrent for a lot of us, right? Especially in a still world context and current economic climate. There's quite a number of us have ideas on the formulation, right? And to be really honest, right? It's almost impossible for us to get these things.
Well, it's almost impossible as an individual, but as he rightly said, it's better to partner. So as an individual, you can do it, but sometimes if you know a company that has the financial resources, if you work at a university that has the financial resources to do it.
Let's just say you.
Yeah, let's say you.
We don't have financial resources. That's the point I'm making, right? So like an individual here who's involved in the same plan, and usually comes up with something. It's big problems, right? It's very difficult at this point. So much so that because you might just publish and and just move on with life, right? And it goes on. I mean, that's a harsh reality.
Yes.
A lot of us in a position like that.
I wouldn't say that you just need financial resources. What I say is that they have to portion up their resources. So we have to sell the future and this thing in the future. It's going to bring in more resources than it consumes. Once you make that case to them, I can't see them taking it. Yeah.
And don't worry, UTT is in entrepreneurial university, so after you have to invest money to get money, isn't it? So you don't need to despair.
Just expand on his point here. A familiar student in the bioengineering faculty had a familiar project accepted by a university in Greece, which awarded a prize. Developed it with a Danish university who built a prototype, patented it, and given you UWI is now getting 20% of the royalty because she was a student. She doesn't get any right because she was only a student in university, and the principal is now making an arrangement to receive that portion of the royalty. So, if you are a staff, I don't know the staff, but if you are a student in university, your rights belong to the university. So that's just expanding on that point. Ladies and gentlemen, if you have no further questions, I thought I've already the last one. Let's thank Mr. Michael Leonard for a very informative seminar on you're doing a tremendous job there, and I must say, you presented this information so easily, so I was able to follow through continuously. Very interesting area, and I'll talk to you about some problems we have with intellectual property rights. With really IPOL business right now with new varieties. So let's say thank you very much again. I hope to see you 1 year from now when we increase the rate on intellectual property rights. So, thank you very much, ladies and gentlemen. And next